The meeting will officially come to order. Will you please call the roll?
Senator Sturville. Here. Delegate Bagby. Here. Delegate Mullen. Delegate Samira. Christy Kelly. James Abrenio.
Present.
Commissioner Land. Who?
Present.
Thank you, Commissioner. Commissioner Oliver, represented today by Senior Policy Analyst Allen.
Present.
Commissioner Storin, represented today by Chief Deputy Commissioner Berger.
Present.
Delegate Price.
Here.
Senator Edwards.
Here.
Mr. Chair, you have a quorum.
Okay, thank you very much. We were concerned that we would have a quorum, but we did. First of all, today's meeting, as you know, is the final meeting of the Joint Subcommittee to study barrier crimes and criminal history records checks. At the end of the meeting, we hope to vote to make a formal recommendation on whether the legislation should be introduced for the upcoming 2022 regular session. Our attorneys will now give a presentation on the changes implemented in the most current draft that we have before us. At this time, I'd like to call on Anna Moore of Legislative Services. Anna, thank you for your good work, and I look forward to your presentation. Thank you.
Thank you, Mr. Chair. Sorry. On your desk, we have provided the agenda, the draft, the accompanying summary, a document that explains the changes that we made in the draft, and the projected fiscal impact information.
Can you speak up so we can all hear? Can everybody hear? Okay.
Today, Sabrina and I are going to run through the changes that we implemented based on the feedback from this joint subcommittee in our last meeting. We are not going to formally go over the projected fiscal impact information, but if you all have questions about it, Mike Tweedy is here in this meeting until 2:45 p.m., and the folks from the state agencies may also be able to help answer questions. After our presentation, we will then hear public comment, and then the members of this joint subcommittee will make a formal recommendation on whether to recommend this legislation for introduction in the 2022 regular session. And this meeting will conclude the work of this joint subcommittee.
Okay. Does everybody have before you the most recent version, 11/5/2021 at 12 o'clock p.m.?
Are they up?
Okay. Make sure everybody has the most recent version.
Mr. Chair, I'm about to share those slides virtually right now.
Okay. Thank you.
Okay, so turning to our slides. It's not going. Oh, you're going to click. Okay. So next slide, please. Okay, so the first change that we have is that we are requiring the boards to establish their waiver processes and their regulations.
Speak up just a little bit so everybody can hear you.
Sure, sorry. I'm losing my voice a little bit too. I apologize.
Yeah. Okay.
So the first change that we have is that we are requiring the boards to establish their waiver processes and regulations. You can see this on page 15 in lines 371 through 375. We are also continuing to require the departments to publish information about the agency's waiver process in an easily accessible format on a website maintained by the department, which should hopefully help with transparency in addition to the regulations. Next slide, please.
Okay. Yeah, if you want to look at page 15, it's 19.2. Let's see, H under H. Want to explain that further?
Mr. Chair, well, this was just based on the recommendation in the last meeting that the members here wanted to require the different boards, the Board of Education, the Board of Health, the Board of Social Services, and the Board of Behavioral Health and Developmental Services to put the waiver process in regulations. So,
Mr. Chair.
Yeah, see you.
Yeah, I just wanted to make sure
Price.
so that we have continuous thought. This was because each board had different eligibility requirements or different things that they were looking for. So this allows them the flexibility to come up with their waiver process for what it is they're looking for.
Delegate Price, yes.
Yeah, so
Thank you.
each board, behavioral health Board of Education, State Board of Health, Board of Social Services, all will have their own separate waiver processes. Is that right?
Mr. Chair, that is correct.
Okay, just want to make sure everybody understands.
Yes.
Thank you.
Sure. So for this next slide, as discussed in the last meeting, we implemented the following changes in subsection H in 19.2-392.02 for more minimum standards around the waiver process. First, we made it so that waivers will not be transferable across the agencies, but it will have a positive impact when another agency is reviewing an application for a waiver to see that a different agency had granted a waiver to that individual. Second, an agency must state the basis for denying an application for a waiver in writing. And third, criteria used to review waivers must be set out in each board's regulations. Next slide, please.
Okay, any questions? Okay, go ahead.
So because the boards are now required to set out the waiver process and regulations, the appeals process in the Administrative Process Act applies, and we made this explicit in subsection H. And it provides that if an individual applies for and does not receive a waiver, he may request an informal fact-finding proceeding under the APA. If he does not request such a proceeding, the initial rejection of the waiver becomes final after 30 days. If the individual does have an informal fact-finding proceeding and still remains aggrieved after that proceeding, he may then seek review of the case with Circuit Court.
Mr. Chairman.
Yes, Senator Serval.
So I appreciate the fact that the appeals process is in there, and I think that's a big improvement. However, I'm curious about whether somebody might be able to refile again later, or whether there needs to be some explicit language that says how often somebody can refile, or maybe like every year or 2 years or something like that, they can seek it. I'd be concerned that if absent any language, it might be read to think that you get one shot at the one crack of the apple and that's it. But it seems to me that circumstances can change over time, and somebody ought to be able to reapply at some point in the future. But we don't want them applying every month or anything.
Sure.
Anna?
Sure, Mr. Chair, Senator Sorrell, that's certainly something that we could implement if the joint subcommittee would like to do that. We can certainly add language in.
Is there any discussion about that?
No.
Yes, Senator Serval.
Thank you. Just trying to think of other sort of corollaries, whether once a year or once every 2 years or once every 5 years. I've been trying to think of other situations where we have something similar to this.
Mr. Chair,
Doug Price.
is it possible that there are any agencies on the meeting that can weigh in on what would be an appropriate timeline if we were to set a once every so-and-so, what that so-and-so would be?
Time frame. If you're turned down once, is there a time frame for filing a new application at some point? 2 years, 1 year, 5 years, whatever. Anybody have any thoughts about that? Any recommendations from any of the agencies? Okay. Yeah. Anna, you have any ideas? Yeah. Go ahead, James.
Yes, and this is a question for Senator Serval, and when it relates to expungement, because I've oftentimes wondered that myself. If you get an expungement denied, and then there's new facts, the job's denied, is there a time limit there? Because I've never actually refiled, and is that illustrative here?
Mr. Chairman.
Senator Serval.
Yeah, I'm not aware of any cases that say whether it's res judicata for forever and ever. Or I would think you could apply based on changed circumstances, just like you can with child support or child custody. If factual circumstances change, then you can seek it again, I would think. But the courts have never really ruled on that I'm aware of.
Well, I'm just wondering, if we're going to... Oh, sorry about that.
Go ahead.
Senator. If that's the case in the expungement statute, perhaps there doesn't need to be a reason here to clarify it here as well. Maybe I'm wrong, but just something to think about.
Is there anything in the current language that says this is it? You have no further change. It's res judicata, so to speak. Yeah, Anna?
Mr. Chair, I don't have the exact language from the Administrative Process Act in front of me, so I'm not sure if after you apply to the circuit court, that's it. But I don't think the way we wrote the language that it would prohibit people from applying for a waiver from a different agency, if that makes sense. Like, say you got rejected from the Department of Health, you could still apply for a waiver from the Department of Education, and then We could also add the language that you can apply for the waiver from whichever agency you were rejected from after 2 years again, if you'd like.
Okay, Senator Serval? You have any
Mr. Chairman,
thoughts?
I think 2 years would be fine, I'm open to alternate. I'm open to a shorter period of time, but I would just say that perhaps 2 years upon a showing there's been a change in circumstances or something like that.
Okay, is there a motion?
Mr. Chairman?
Yeah, Senator Price. Delegate Price.
I do understand the sentiment behind it. I would love for there to be explicit language that does say you can reapply if you've been rejected, but I don't know that I support a 2-year time frame without hearing more from. I don't like. I know we're using, models of how other things have worked, but for nobody to be able to chime in and say, what it would be from on the ground. Can we put a pin in that vote and come back to it, Mr. Chair?
How about something along the lines of upon a change of circumstances, or if there's new information that the applicant can file a new application
Mr. Chairman.
upon a change of circumstance or something of that nature.
Mr. Chairman.
Senator Serval?
I think the correct language would probably be a material change in circumstance.
Right, yeah.
Yeah.
Material change of circumstances?
Commissioner Land has her hand raised.
I can't hear you.
Pardon me, Mr. Chair. Commissioner Land has her hand raised.
Okay, Commissioner Land, where are you?
Yeah, I would say the same. If there's been a material change, that we would be willing to relook at it. I mean, that makes a lot of sense.
Okay, so why don't we look at that and come back to it and see if we can't come up with some language we can agree on and upon a material change of circumstance. Anybody else have any comments about that? Does make sense. Okay.
So moved.
Okay. Okay. The motion is made, and is there a second?
Second.
Okay. In concept, motion is made and seconded in concept that upon a material change of circumstances, an applicant can refile for a waiver.
Mr. Chair, I'm fine with that being a voice. I'm fine with that being a voice vote.
Yeah. Okay. Is there all in favor? Say aye. Aye.
Aye.
All opposed, no. I can't hear. What was that?
Mr. Chair, I think there may have been one no, but the ayes have it.
One no. Okay.
I couldn't quite hear that.
Okay. I can't tell. Let's go ahead and vote. Go to call the roll.
Yes, Mr. Chair. Senator Serval? Aye. Delegate Bagby? Aye. Delegate Samira?
Aye.
Christy Kelly? Christy Kelly? Okay. James Abrenio?
Aye.
Yes.
Delegate Price?
Yes.
Senator Edwards?
Aye.
Mr. Chair, that's 7 ayes, 0 noes.
Okay, 7-0, the motion carries. Okay, Anna, go ahead. Next.
Mr. Chair, if you go to the next slide, please.
Where are we? What line?
We are going to be towards the end of the draft here. We're going to be on page 61 in lines 1616 through 1625. This is the phased implementation of the waiver process so as to not overwhelm agencies with applications upon enactment.
Speak a little bit louder if you don't mind. It's kind of hard to hear.
Sure.
Yeah.
So this was brought up in the last meeting because of a concern with applications getting backlogged because of too many applications coming in all at once as soon as this law becomes effective. Because the agencies will have a few years to develop this process and will have a better idea of how many applications they will receive based on their regulations, we decided to make this agency specific and permissive. The language requires the departments, upon enactment, to begin accepting at least some or all application for waivers, but in its regulations, each board may set out a phased implementation of the regulations that shall not exceed a period of 2 years after the date of enactment before the waiver process, application process under each department becomes fully functioning.
Okay, on line 1616, the act won't go into effect until July 1, 2025?
Mr. Chair, yes, the law doesn't become effective until July 1st, 2025.
I want to make sure everybody understands that. Will not be till 2025, July 1.
Mr. Chair, yes.
Okay, thank you.
Next slide, please. Thank you. So because we are eliminating the current exceptions to barrier crimes in the code, as such information is going to be required to set out in each agency's waiver process to ensure that those currently working pursuant to one of the exceptions, waiver, or screening processes in the code up until the date of enactment do not lose their jobs. We are grandfathering in those individuals as long as they continue to work in their current position. If they choose to leave the job and apply for another job subject to the waiver process, they would then have to apply for a waiver. Due to some feedback, we also added an option for the boards as part of their regulations to require that an individual subject to one of these former waiver exceptions or screening process could have 1 year after enactment to file an application for a new waiver, and that the individual cannot be terminated for lacking a new waiver while his waiver application is pending. So we're basically giving the boards the option to either grandfather these people in or give them 1 year to get a new waiver.
Okay, everybody understand that? Grandfathered or 1 year if you're already in a position. Okay, thank you.
Next slide, please. Okay, so navigation system. Delegate Price discussed this as a potential system that could be created to help individuals navigate the waiver process across the different agencies. Because this would need to be placed centrally in an agency that is different than the ones creating the waiver process, and that the waiver processes have not yet been developed. This is an issue that we direct the Secretaries of Education, Health and Human Resources, and Labor to explore so that they can do so in tandem with the boards as they develop the regulations. And we directed the secretaries to report their recommendations on the potential development of the navigation system 1 year prior to enactment so that it could hopefully be created by or around the time that the process will become effective.
So to clarify, each agency will have till no later than July 1, 2024 to develop a navigation system to assist applicants in figuring out how to follow the waiver process.
Mr. Chair, it won't be the agencies doing it. It'll be the Secretaries of Education, Health and Human Resources, and Labor who will be making the recommendations on it because the thought was that navigators should be in a third-party agency and not in one of these agencies because it could potentially open up agencies to legal challenges about their waiver process if they're making decisions, about the waiver process and also helping people while they're applying. So in order to get that developed, that's why we brought in the secretaries.
The secretaries, and they will make a recommendation to the chairs of the respective committees in the House and the Senate. Is that right?
Mr. Chair, that's right, yes.
Okay. Make sure everybody understands this.
Thank you. Okay, and next slide, and I'll turn it over to Sabrina.
Okay, Sabrina. Okay, Sabrina Miller Bryson.
Thank you, Mr. Chair.
Welcome, Sabrina.
Thank you so much. Oh, sorry. Okay. So on pages 11 through 12, which is lines 271 through 293, the only portion of this that has changed since the meeting that we had in August is the removal of misdemeanor assault and battery in 18.2-57. So this is one of the points that we had discussed, or the members of the subcommittee had discussed during the August meeting, and the full list of crimes that have either been eliminated or changed to misdemeanor only are on this slide.
Okay.
All right, next
and
slide.
that would be page 11, okay.
Oh. Yes, Mr. Chair. And then on page 16, lines 402 through 406, as discussed in the last meeting, we added a penalty for unlawful dissemination of information related to barrier crimes. This is the same penalty as found in code sections related to the sealing and expungement of criminal records.
Okay. Same thing, same approach, okay?
That's correct. Yes, Mr.
Okay.
Chair.
Thank you.
Sean, if you could go to the next slide. Thank you. These are kind of short. And then similarly, the members discussed last time keeping some sort of penalty for a qualified entity that either discharges or in another manner discriminates against an individual based solely on a barrier crimes conviction. This draft retains a little bit of that language from the prior draft and created a new penalty allowing a complainant to recover not more than 12 months of lost wages along with attorney's fees and costs.
Okay, any question about that? I think Cyril, you came up with this idea?
Yeah, I'm reading it right now, Mr. Chairman.
Okay. Make sure everybody had a chance to read this. Lines 407, 411 on page 16 and 17.
Should I move on? Mr. Chair, would you like me to move on or?
Yeah, go
give
ahead.
him a-
It's 407 to 411. It's on 16.
That's correct.
Okay, that's where that is. Any questions about this matter?
Mr. Chair?
Sorry.
Yeah, we're not-
That's fine.
Yes.
Push
One
it.
question about the change on lines 407 through 411. It says if an individual is granted a waiver pursuant to subsection H, shall not discharge or in any other manner discriminate. How does that pair with the, I believe it was third enactment clause that allowed agencies the option to either grandfather them or to have them pursue a waiver?
Yeah, good question. Okay, Sabrina? Can you explain that?
Mr. Chair, yes, I'm sorry.
Yeah, go ahead. Yeah, let's make sure everybody can hear.
No,
now.
I'm looking now. Mr. Chair, unfortunately, and Rebecca, or Ms. Allen, to your point, unfortunately am not fully prepared for an answer on that, but I'd be happy to look into it, unless Anna, if you have any ideas. But it wasn't something that I considered, so I can absolutely look into it and.
Okay,
Yeah.
all right.
Mr. Chairman?
Yeah, Senator Serval.
Thank you. I got a couple of questions.
Yeah, go ahead.
Had a chance to look at it. So first of all, I guess where we are right now is on subsection J on line 407 to 411, right?
Right,
So,
page 16.
the way I read it right now, maybe council correct me if I'm wrong, but the way I read it, the anti-discrimination provisions and/or liability would only apply to qualified entities, which are only private companies, private actors. Is that right? Private businesses.
Mr. Chair and Senator Serval, let me just scroll up to that.
Sabrina, go ahead.
Sure. On line 329 in 19.2, 392.02, that same code section, qualified entity is defined as a business or organization that provides care to children or the elderly or disabled, whether governmental, private, for-profit, nonprofit, or voluntary.
You've answered that question. Thank you. Good. Okay. Secondly, with regard to the language you've written for 402 to 406, it says that a violation of this code section shall be subject to the penalty provisions in subsection G of 19.2 392.6. 16. And correct. And so when I look at that, that provision provides that if you violate that code section, you get a penalty of $1,000 or actual damages, whichever is greater. I guess that language is broad enough to encompass the entire remedy and not just the $1,000 penalty. That is correct, Mr. Chair, Senator Serval. Initially, in the previous draft from the August meeting, we had it written out in its entirety, and instead, because the effective dates now line up, we have just referenced 19.2 392.16. But it should be that whole subsection. Yeah. That's included. Okay, I think I'm okay with that. Okay, thank you.
This is kind of like a civil rights case. This portion of it, right?
Right.
That's correct, Mr. Chair.
Okay. Okay. Any question about that? As a private entity, a qualified entity, shall not discharge or in any way discriminate against a person solely because of conviction of a barrier crime subject to a waiver. Is that what you want to say?
That's correct, Mr. Chair.
Okay. Okay. I want to make sure everybody understands. Okay. All right. Next.
You can go to the next slide, John. Thank you.
Sabrina? Yeah.
Yes. Thank you, Mr. Chair. As also discussed in the previous meeting, the FOIA considerations are included on lines 412 through 420. That is 19.239202, subsection K. This subsection provides that any waiver application, regardless of whether the waiver is granted, will be exempt from FOIA except for an application cover sheet and the status of the waiver application. This change came directly out of the joint subcommittee's discussion last time.
So this is a privacy issue here, right?
That's correct,
The only
Mr.
thing that
Chair.
would not be private would be the application and the decision. Is that right?
That's correct, Mr. Chair. And just to clarify, the status of the decision does not include the written findings and basis of the decision, as that could also contain some of the sensitive information that we're trying to
privacy
exempt.
issues, okay?
Correct.
Any questions about that? Okay, next.
Next slide. Thank you, Sean. And then on page 60, lines 1600 through 1604, we have the second enactment clause that directs the departments to promulgate regulations to implement. Did you already go over this? No. Okay. To promulgate regulations to implement the waiver process by July 1st, 2025, with the exception of the provisions relating to foster and adoptive parents. We have been informed by the state police that they should be able to incorporate the barrier crimes waiver information into the criminal history background checks during the same upgrades that they'll be implementing as required by SB 1339, which is the record sealing and expungement bill from the 2021 special session.
Okay. Anybody have any questions about this? Okay. Any questions? Okay.
And then, Sean, I have my final slide.
Yeah.
And then finally, we added an enactment clause on lines 1635 through 1637, directing the state police to implement any necessary updates to their criminal history and wrap back information system, so an individual's criminal history also reflects when a barrier crime waiver has been granted.
Okay. State police shall implement enhancements to the criminal history and so forth, including the ability to add or remove barrier crime convictions, waivers, by July 1, 2025, right?
That's correct, Mr. Chair.
Okay. Everybody understand that? Okay.
And Mr. Chair, I believe that is all we have.
Okay. Let's go back to page 11. It's barrier crime definition on line 271 under section 19.2-392.02, national background checks by businesses and organizations regarding employees or volunteers providing care to children or the elderly or disabled. It's my understanding that this provision, barrier crime definition, beginning with line 270, that goes on to the next page, includes all the barrier crimes that there are. Right now, they're spread all over the place. This includes all the barrier crimes that we're talking about. Is that right? In the code.
Mr. Chair, that's correct. They are and continue to be contained to this section.
The importance of this is they're in one spot. They're not spread all over the place like they are today, right?
Mr. Chair, they actually are currently contained just in this subsection. We did do a little bit of reorganization, so it's a little bit more clear as far as what constitutes any violation and what constitutes only a felony violation.
Okay. And it's limited to felonies. And explain again to make sure everybody understands this. The crimes that have been eliminated, including some misdemeanors, and you want to explain which ones they are. And starting with 18.2-88. Is that right?
Yes, Mr. Chair.
Okay. Which ones are eliminating that are just strictly misdemeanors?
Mr. Chair, give me one moment and I will. Thank you. So the crimes currently that have been eliminated completely are 18.2-88, which is carelessly damaging property by fire. That is a class 4 misdemeanor. 18.2, 57.01, which is pointing a laser at a law enforcement officer, unlawful penalty. That's a class 2 misdemeanor. We have 18.287.1, which is setting off chemical bombs capable of producing smoke in certain public buildings, which is also a Class 2 misdemeanor. And then we have 18.2-56, hazing unlawful, civil and criminal liability, duty of school, etc., officials penalty, which is a Class 1 misdemeanor.
All right, everybody's fine with eliminating these misdemeanors, okay? Any questions? All right. The next is these categories, the felony-only categories, eliminating the misdemeanor offense and some other categories. 18.2-36.1. Want to explain those two?
Yes,
There are
Mr. Chair.
Four of those, I believe.
Absolutely. So these are four code sections where we eliminated the misdemeanor provisions, and all of these code sections contain both misdemeanor and felony provisions. So we have 18.2-56.1, which is reckless handling of firearms, reckless handling while hunting. We have 18.2-57, so we've eliminated just the misdemeanor assault and battery provisions there. We have 18.2-57.02, disarming a law enforcement officer or correctional officer, and the misdemeanor provisions here that we've eliminated apply only to impact weapons or chemical irritants, I believe. Then we have finally 18.2-60, which is threats of death or bodily injury to a person or member of his family, threats of death or bodily injury to persons on school property, or threats of death or bodily injury to healthcare providers. And the misdemeanor provisions here that we've eliminated are oral threats only and do not include the felony felonies of written or otherwise communicated threats are still included.
Misdemeanor threats that are oral
They're
threats
oral threats,
only.
that's correct.
Okay, those have been eliminated. Okay, any questions about those? Okay. All right. Anybody on the board, on the commission, have any comments or any questions or concerns?
Mr. Chair.
Doug Price.
Yeah, I just wanted to make sure, did we circle back on the outstanding question about, because I didn't understand the question, so I just wanted to make sure, was there misalignment between one section and another? Were we still waiting to hear back on that one question?
Mr. Chair, Delegate Price, I'm not sure if I understood totally correctly. So, Rebecca, I've kind of worked on this, and you can let me know if I'm totally off base.
Push your microphone.
Yes, sorry, I keep messing that up. So the concern was about how the provisions in 19.2-392.02, specifically the, was it H, I, J, and K, would go with the third enactment clause for the people who are getting grandfathered in. Was that the question?
The grandfathering issue?
Mr. Chair.
Yeah.
So to
Go ahead,
res-
Alan,
Yes.
go ahead.
We can do that.
To respond to you, Anna, so enactment clause 3, as explained, was that it would allow the respective agencies to either grandfather those individuals who have are taking advantage of current existing waivers or automatic exemptions in the Code of Virginia, or to have them seek out a waiver. The boards would have the ability to choose that. So my question was, if a board were to choose the option of, we'll just grandfather them, assuming they stay in their same position, how does that square with line 407, where it says, starting on 407, if an individual is granted a waiver, qualified entity shall not discharge or in any other manner discriminate. So I just wanted to make sure, since you would have a situation where a person wouldn't have a waiver, they were grandfathered, would to what extent would J protect them from discrimination, or is there a protection for discrimination buried in enactment clause 3?
Sabrina? Or
Take this one. Okay, sure.
Anna?
Mr. Chair, Rebecca, no, that's definitely a good question. My thought was if they were grandfathered in, they wouldn't be subject to those provisions, but we can put in an explicit sentence in enactment clause 3 that would say that either those sections apply or don't apply to those people who are grandfathered in, depending on the will of the joint subcommittee. Does that make sense? Okay.
Mr. Chair.
Yes, Delegate Price.
I'm sorry, I might be having a moment, but are we just basically saying that if they have a job and they're grandfathered in. We just want to make sure that as they stay in that job, they're protected from discrimination. Yeah, so I would support that that language. I know we're going to wait to see it, but
Pretty sure, Mr. Chair. Yep, as part, yeah, we'll definitely make a note and make sure that that is implemented.
So let me make clear. If you're either your grandfather or you're not, so it's grandfathered, and you cannot be, well, of course, if something happens, you're charged with something, it's a different matter.
Well, I think, Mr. Chair, I think that this is just to make sure that whoever these people are, whatever qualified entity they're working for, can't terminate them. Probably, I would guess, right, based on the barrier crime, they would have the same protections as the people with the new waiver. And I think we can do that just with one sentence. It should be really easy to do.
Mr. Chair, if I could
James?
And I think Senator Serval brought up this issue before, but I wonder if we say that you grant somebody a grandfather provision, and then we say, and if you then violate that, you can be sued. Would that discourage entities from grandfathering people in? I just want to make sure that we're not inadvertently making it harder for people to get grandfathered in.
Any
Does that
comments?
make sense?
Yeah, Senator Serval. Any comments? The grandfathering measure.
No, I was a little distracted. Could you, maybe you could restate the question?
Yeah, state the question.
So we're discussing whether or not we grant civil protection for people that are granted waivers, and we're saying if you're protected with a waiver, you can't be discriminated against, and if you do, you're sued. The question is, do we also have that civil protection applied for people that are grandfathered in? My concern would be an employer would grandfather, or an entity would grandfather somebody in and then be worried about getting sued, so they wouldn't grandfather in. And I think that I said that's even more convolutedly than I said before. But I just want to make sure that we're encouraging grandfathering people in.
Mr. Chair?
Yeah, Ms. Allen, is that right?
Yes, it is. To respond to your question, the grandfathering wouldn't be done by the qualified entity. It'd be done by the respective agency. They would have the choice of, do we want to establish a grandfathering provision, or do we want those who are using the existing exemptions to come to us and ask for a waiver, so we have a record of them having gotten a waiver. So the question I had here is, the way it's written, it wasn't clear to me that if an agency decided we'll create a grandfathering provision for them, that those folks would be protected from the anti-discrimination.
Mr. Chairman.
Yeah, Senator Serval.
Can somebody just articulate a narrative and an example of somebody who would be potentially grandfathered?
Yeah, give an example. I'm having trouble too understanding if somebody is still in a position and they've not been, denied the position. Why would you need grandfathering? Yes, Delegate Price.
The thing that came to mind, and maybe one of the agency chairs could answer, the thing that came to mind with me is somebody was grandfathered under one set of leaders and leadership changed, that they would still be protected within that position as if a waiver had been processed should leadership change and a new director or something come in. But we can't, I mean, just because somebody has a position and gets grandfathered in doesn't mean that they won't ever be discriminated against for having had a barrier crime.
But they've been hard to begin with, though.
Well, we definitely know that there are different philosophies with different directors under different agencies and private entities.
Yeah, okay. All right, Ms. Allen?
Mr. Chair, so I can only speak for the way that VDH's statutes are currently written. Right now, if you have a barrier crime conviction, in almost all circumstances, you're not going to be able to be employed because it's just a hard no. There is one exception that's written in, and that's if you have a single misdemeanor that's more than 5 years old that did not involve abuse or neglect. So if you have that one limited exception, a employer can go ahead and employ you despite having that barrier crime on your record. You don't have to come to the agency and ask for any sort of exception or waiver. The way that the draft legislation has been written before us, that automatic exemption that's already built in has been struck. So the question from our agency was, what do we do with those individuals who are employed taking advantage of that exemption that is in the code? Because if you strike it, then it no longer exists. What do we do with them? And so that's why enactment clause 3, I believe, was written in, but I would defer to Sabrina and Ann on that.
So you like the enactment clause the way it's written? But the grandfathering?
Mr. Chair, so our VDH's feedback to Anna and Sabrina were that, because originally it was grandfathering only, I'm sorry.
Go ahead. Explain yourself further, Ms.
Sure.
Allen.
We had requested consideration of having, give the agency the option to have a waiver process put in even for those people who are grandfathered, because we were concerned that a person, because of the way the grandfathering was written, they'd have to be in the same position. There'd be a lot of questions about, well, what constitutes the same position? Is it the same position if the title stays the same, but the job responsibilities shift? What if these individuals were up for a promotional opportunity? Would they be barred from promotions until they got that waiver? So we asked for that sort of flexibility to be put into enactment clause 3. But now that because of the grandfathering provision not being addressed in this other provision, I just wanted a consistent answer as to whether or not the folks who would use grandfathering would be covered.
Okay. Yeah, Senator Searle?
Mr. Chairman, let me try and articulate this. So, say there's some guy who got a assault and battery conviction 20 years ago, and he got hired to do what job? Give me a job.
They could be a CNA at a nursing home, a certified nursing
Okay,
assistant.
certified nursing assistant. So you have somebody who got an assault and battery 20 years ago, and they've been hired to be a certified nursing assistant because it was so long ago and it was a misdemeanor and there was only one. They were able to be hired. And so what we're concerned about is if they apply for a different job, what? I see you're shaking your head.
Mr. Chair?
Yeah, go ahead.
It's not if they would apply for a new job. It's once this law would go into effect, July 1, 2025, we were concerned that employers would then not know what to do with those individuals. So, yes, this person who's got that as misdemeanor assault and battery from 20 years ago, I hired them to be a CNA at a nursing home. This law passes, that exemption that I relied on to hire this person on no longer exists. So do I get to continue to keep this person on my staff? Or do they need to go out and get a waiver? Do I need to take them off of direct care of patients or residents, I should say, while they're pending that waiver? Do I need to terminate them? So I think that's what enactment clause 3 is aimed at.
Okay, which enactment clause, whereabouts on line what?
Mr. Chair, it's enactment clause 3, lines 1605 through 1615.
Okay. See, all right. And you're saying, Ms. Allen, that you like the clause the way it's written?
Mr. Chairman?
Yeah, Senator Searle.
So, first of all, back to, I think, Ms. Allen's original question way back when, under 401 through, lines 401 through 407 through 411. No.
Mr.
Okay,
Chair.
yeah, it is 401 through 407. Yeah, I think we would need to make it clear that if you were currently employed at the time the law became effective pursuant to a grandfathering provision, you also could benefit from the non-discrimination provision. Yeah, and I think that does need to be included because otherwise you don't have the same standing. But I would think, I mean, and my only concern would be whether or not the employer would have notice, but obviously if the employer hired the person, I assume they knew about the conviction and hired them notwithstanding that, so there should be notice to the employer of that, so everybody should be on the same page going into it, right?
Mr. Chair, if I may?
Yeah, Ms. Allen, go ahead.
That's correct. And again, only speaking for Department of Health, we do work closely with our stakeholders, our nursing homes, home care organizations, and hospice. So depending on what piece of legislation is ultimately passed, we would communicate with all of them about what the changes are, when the changes are in effect, and how that impacts their hiring practices so that everyone is on the same page.
Mr. Chairman?
Yes, Senator Sherrill.
So if somebody who's my example, person here that had the 20-year-old A and B who's employed as a CNA decide he's working at the Inova Mount Vernon Hospital down the street from me, or whatever, some nursing home, and wants to change jobs after this passes. Does that person then have to have a waiver, go get a waiver to get a new job? Okay. And are the regulations gonna, okay, never mind. Okay, all right.
That makes sense. I mean, the way it's written now, makes sense to me, I think. Anybody have any further questions? Yeah, Delegate Price.
Mr. Chair, I know that we've been voting on things that we were adding based in concept. I would make a motion that we add to make sure in concept that those that were grandfathered in have the same non-discrimination standing as Ms. Allen has suggested. I would move that.
Is there a second?
Second.
Second, been moved and seconded. Anna, my understanding, that's the way it's written now, correct? Is that correct? The way she explained it is the way it's written now.
Mr. Chair, the way Delegate Price just explained
Yeah.
it, well, we're going to add that sentence that she just explained to clear up any confusion,
Okay,
to make
just in
up the way.
case it's-
Yeah, it'll just be a
okay.
one
That's
sentence and
the
it'll take care of the
intention.
issues. Yes,
All
yes,
right,
sir.
any further discussion on the motion? Let's call the roll.
Senator Serval. Delegate Bagby. Delegate Samira.
Aye.
Christy Kelly.
Aye.
James Abrenio.
Yes.
Delegate Price.
Yes.
Senator Edwards.
Aye.
Ayes 7, no 0.
Okay, we're going to put some clarifying language to make sure there's no question. Okay. Any other questions? Any other concerns? Anybody on the panel has anything to say about it?
Yes, Mr. Chair.
Yeah, Delegate Price.
Yes, I just do want to thank the attorneys that were working on this. I feel that you all listened and captured the feedback from all of the meetings that we've had, and really pleased with the work product that you came before us with today.
Yeah, I want to second that. Anna and Sabrina, y'all have done a fantastic job, and I really appreciate all the work you've done. I know it's been a hard task, and we've made some changes, but I think you've done a great job. Any further questions? All right, shall we open it up now to public comment? Anybody from the public would like to comment? Here we come up.
Members of the public who would like to speak, please line up behind the dais presently. I'd like to get a look at how many of you there are.
Just one. Okay.
Thank you very much. And I really just have a question, and it's more clarification on what you have been talking about. My name is Jennifer Federa. I'm the Executive Director of the Virginia Network of Private Providers. Work very closely with a number of behavioral health, developmental disability providers, private sector across the Commonwealth. Currently, in 37.2416, which is the section of the code applicable to the private sector in behavioral health, in section F, it talks about, or paragraph F, it talks about, in lots of words, if you have been, you may be hired if you have been convicted of not more than one misdemeanor offense, 18.257 or 18.2-57.2, or any substantially similar offense. I understand that you are removing from the list of misdemeanors that would be just removed. You took off of that the assault and battery one, and I understand that. I absolutely get that. I guess going back to some of what the representative of the Department of Health, Delegate Price and Senator Serval were talking about, I think this is creating a very complex and complicated thing that maybe if the enactment clause specified anyone employed prior to fill in the date, this simply didn't apply to. They were employed legally under the code as it existed at the time. They didn't have to be grandfathered. They didn't have to be a waiver. I guess my concern is a lot of what has been said. This person is now perhaps grandfathered in. We want to protect them. They're not going to be fired for their barrier crime. They've been with the employer for a period of time. Seems highly unlikely that now we would turn around and fire them for their barrier crime, but okay, I understand needing the civil protections that you've talked about, Delegate Price. But then if they might be able to apply for a promotion to a supervisor, they're now going to have to go through a process to get this waiver. It won't be a 2-day process. We know that. It's going to be, which will potentially eliminate their ability to get that job. If ownership changes of the company, license changes, the grandfathering, I think, probably disappears. I'm not a lawyer. I don't know, but I would think it may disappear. That person is now in jeopardy because they don't have a waiver. I'm just asking, I think, if there's any reason not to, at the date of whatever date you pick, simply say anyone who is employed legally under the code as it exists at the time is under that set of rules. I'm feeling very inadequate here because I'm up against a bunch of lawyers on the panel, and I don't want to say the wrong thing. But so that's my question.
But it depends on the facts of the situation, as a lawyer would say.
I wasn't going to say that, Senator.
Yeah,
I was not going to say that.
Yeah, I think it does open it up to some questions. I think you're right, some potential litigation.
I think we can make this simpler and accomplish what you're trying to accomplish is to have people who have been perhaps bad actors at some point, but not terribly bad actors, be able to be employed. And that's what we're trying to do.
Yeah.
Let's not mess up the lives of those people who are able to be employed and are already employed. Let's not make it worse for them.
You think we ought to just take the whole thing out or leave it in the way it is? Or I don't know how you fix it much better, frankly.
I think rather than, laws have effective dates. So individuals legally employed prior to this law doesn't apply to.
Mr. Chair?
Yeah, James?
And maybe I jumped over what it meant to be grandfathered because I thought that that's what we were doing, but maybe, and I'm a lawyer, so I messed that up. Maybe we could use some language to the effect of if an employee has been hired previously on a prior version of this statute, that shall apply or something to that language, just to make it clearer, because I think language can just clarify that pretty easily.
My fear was that the way the grandfathering was, I'm sorry, the way the grandfather, and what I was hearing, and I may not have been hearing it correctly, is as long as they stayed in the same position, that limits them. And that if they wanted a promotion, they'd have to go get a waiver. That causes a problem that may not need to be caused. So those were the two things I was concerned about. And I understand the civil protections piece of it. I'm a little concerned about that in general, simply because the employer. Generically, the employer, in my opinion, still has the right to decide if they want to hire this person or not. You're qualified for this job or you're not. I mean, you fit this job or you don't. And it may have nothing to do with the barrier crime that employer decides you're not right for this job. With that extra piece in there, there's the ability to, well, they didn't hire me because I have a barrier crime. No, we didn't hire you because you showed up late for every interview and, didn't show up for 2 of them. So that's a little bit of an intimidation for employers. We can live with that. I think this other piece I'd like to see that changed.
How would you want, which piece to be changed?
The piece that says that someone who was hired under the code as it exists now, for behavioral health, for the health department, for anybody, whatever the effective date of this law is, if they're already employed, they were hired under the previous law, they're good to go. That's it. You're done.
I think that's what it says.
Well,
Isn't it?
I'm not sure it is.
Okay, Anna?
Mr. Chair, it is what it says. I think the part that she is concerned about is on line 610 at the end when it says so long as he serves in such position. She's concerned about promotion. So if that they would have to, if they're in this position, they're doing really well and they want to apply for a promotion, that they would have to go get a waiver, because the way we have it now is that they have to serve in the same position to be grandfathered in. So I guess maybe something we could do, because I do think, if you are grandfathered in, say with a certain job, you should probably maybe have, I'm not making a policy, but I don't really see that one of the other departments would be okay with just accepting that person without the waiver once the waiver process is in effect. But so maybe we could add something there, so long as he serves in such position or a promotional position directly related to their current position, or however you all want to do it.
Mr. Chair.
Yeah, Senator Delegate Price.
What the pushback that we had gotten before, the whole reason why we have the agencies coming up with the regs is because each different department has different things that they are looking for within this process. Could we just say within the department, so that it's not so super prescriptive, because it might be a lateral move, it could be a promotion, whatever it is. I would love to hear, because we want to be careful, are there any unintended consequences with doing that? Because I do think when I hear grandfathered, that is exactly what I thought, but then until you get to that line where it says position. So if we change that to department, is there any feedback? I'm open.
Employer.
Oh, yeah, I'm sorry, because it's public, private, all of that. Yeah, so to within that employer.
Or, yeah, I think that would be the technical.
Yeah, Commissioner Land, I don't see you.
Hi. I was just thinking that there could be, that an employer would lose their licensure, and then so that person would need to be able to go to another provider potentially as well. So I like the idea of making it within a department, like Delegate Price mentioned.
So change the word, so long as he serves in such strike position in such department? No, you don't want that.
Mr. Chair.
Or agency, or.
It doesn't.
Go ahead.
Currently, is my microphone on?
Yeah.
Okay. Currently, if in Commissioner Land's concern, and I appreciate that, if the provider goes out of business, closes, whatever, and staff wish to go work for another provider, they currently have to go back through the background checks, all that. So if the law has changed at that point, they will have to then go get a waiver. That's fine.
Okay.
I mean, it's a different job. But I would think within the same employer would be, because as an employer, you've made the decision you want to hire this person, you then are okay with them being in any department you have.
You want to say something like, so long as he serves in a similar position with the same employer? No?
Or just same employer.
That could work.
In a similar position?
Mr. Chair.
Senator Delegate Price.
Yeah, the only thing I would say, I agree with the same employer, but similar position, I just want to make sure it doesn't cause confusion if they're trying to get that promotion.
No.
So if we just said within the same employer, would that not cover the concerns that we've heard?
I think so.
So long as he serves with the same employer.
Continues employment, or continues to be employed by the same employer.
Okay, so that was.
I'm sure there's a better way to say that.
He continues to serve with the same employer, right? Continues to serve with the same employer instead of in such position. Mm-hmm. Is that right? Okay, so long as he serves with the same employer.
Mr. Chair.
All right, yeah. Allen, Ms. Allen?
Thank you, Mr. Chair. So when we say employer, I just, for purposes of clarification, is the employer the regulated entity? So let's take the nursing home example. Is the employer the nursing home that holds the license? Because whenever there's a change of ownership, and I believe our commenter mentioned this, whenever there's a change of ownership, a new license has to be issued. So would that constitute a change, would that constitute a new employer? So then the grandfathering wouldn't apply to those individuals anymore.
I believe now, if a license changes, that someone who is, well, no, I guess someone who is currently employed would stay because they were hired by the previous employer, legally hired. I think maybe that has to go in regulation.
So what do we, if we say, so long as he serves with the same employer, we're okay with that?
And then clarify in regulation what happens when a license changes. Because it's a license does not define the employer, it's the tax number actually that defines the employer.
How about?
And if there's new ownership, there's a new tax number. I mean.
If we say, so long as he serves the same licensed employer, does that do it?
I would just say employer and let the regulations take care of it. That would be my suggestion.
Okay, any other? Delegate Price?
Mr. Chair, I move that we would, is that an actual language change, or do you want us to do in concept while you work it through?
Let's go ahead and do it.
Mr. Chair, yeah, everything will probably technically be in concept here, but we have it all here. So we'll
Got you.
make sure it's
So I
good to go,
move that in concept we would say within the same employer as opposed to position.
Okay. Is there a second? Any discussion? You ready to vote? All in favor of the conceptual motion that would be the, so long as he serves with the same employer in concept. All in favor of that motion, vote, go ahead and vote. Call the roll.
Yes, Mr. Chair. Senator Surville. Aye. Delegate Bagby. Aye. Delegate Samira.
Aye.
Christy Kelly. Christy Kelly.
Yes.
Thank you. James Abrenio.
Yes.
Delegate Price.
Yes.
Senator Edwards.
Aye.
Ayes 7, no 0.
7-0. Okay, we're on a roll here, all right? Got a lot of concepts out there. Is there any further discussion on the bill by anybody on the committee? All right, we've already gotten one member of the public, and now we go into other members of the public. Yeah.
Mr. Chair, thank you. There are presently 3 members of the public here to comment virtually. I'll be moving Debbie Taylor in first. Mark Gonzalez, you'll go next. After I've moved you in and introduce you, please begin your testimony immediately.
Okay, who's this person?
Mr. Chair, Debbie Taylor will go first.
Debbie Taylor. Debbie
That's right,
Taylor.
Mr. Chair.
Welcome. Debbie Taylor, you here?
Ms. Taylor, you're welcome to begin your testimony.
Okay, sorry, I need to unmute. Thank you very much. I have a quick question, and I apologize. I was not at the last meeting. I was in surgery. And I just have a question. Is there any type of emergency or language for individuals applying for positions now until 2025 that could speed up the process of waivers? Are there any, because that's 2.5 years that we're still not going to be able to hire people that technically would be qualified, hopefully within 2.5 years. I'm just wondering if there's anything that we can do about that, sir? Thank you.
Okay, and Debbie, who are you? Who do you?
Oh, I'm so sorry.
That's okay.
I run substance abuse treatment programs. I've run Vanguard Services, Phoenix House, National Capital Treatment and Recovery. We have 8 residential treatment programs in Arlington, Virginia, and have operated in the Commonwealth for 60 years.
Okay, thank you very much. The answer to the question is no. Anna, explain.
Mr. Chair, yes. So know that until that time period, nobody will be able to apply for the new waivers. The laws as they are written right now will apply until enactment on July 1, 2025. I'm not sure if the members have, something else they'd like to put in about that, but as of now.
The reason being?
Mr. Chairman.
Go ahead, Anna. I'm sorry. Sabrina? The reason being for the delay?
Mr. Chair, a big portion of this has to do with the Department of State Police being able to incorporate the granting of the waiver into the criminal history background check. And that is getting swept up in the same upgrades that are taking place due to the record sealing and expungement bill from the 2021 special session. And so that is the effective date there. And so we are
Mr. Chairman.
aligning everything.
Senator Serval.
Mr. Chairman, actually, that's actually not the effective date. The effective date is July 1 of 2025 or earlier if the state police certifies they're able to get their computers up to speed faster than that. And I think we probably ought to put parallel language in this bill so that it's identical to what we passed in the sealing bill.
Mr. Chair and Senator Serval, we absolutely can do that. One of the reasons that we had gone with the later date here was simply for the agencies to be able to have a solid time frame to implement their regulations. But if we want to put in more specific language about the due date for their regulations, that's a little, that could be a little bit earlier. I think that's something that we could do.
Sure, you want to have a motion to
Sure,
make them
Mr.
parallel?
Chairman. Yeah, Mr. Chairman, I would the expungement / sealing legislation had I think a separate date for the regulations as well, because there were some regulations required by the state police, and I think under the Regulation Act or whatever it is, law, it usually takes about a year and a half or something to promulgate regs and finalize them, something like that. But anyway, my motion would be that we make the effective date the same language as whatever we have in the sealing legislation, and that we have a separate or additional language in one of the enactment clauses that the regulations are to be promulgated, as soon as possible, but effective, consistent with the final enactment date or something like that.
Okay, we've got a motion on that. Is there a second? Delegate Price? Second. Okay, any discussion? We're making them parallel now. Everybody understand that? Maybe it could be sooner, in other words. We'll see. We okay with that? Okay, there's a motion has been made and seconded. Call the roll. Vote aye if you like it. No if you don't.
Yes, Mr. Chair. Senator Serval. Aye. Delegate Bagby. Aye. Delegate Samara.
Aye.
Christy Kelly.
Aye.
James Abrenio.
Yes.
Delegate Price.
Aye.
Senator Edwards.
Aye.
Ayes 7, no 0.
Okay, 7-0. Okay, well, like I say, on a roll here, okay? All right, I don't know if I hope it helps to answer the question of Debbie Taylor, that we're going to move it along as quickly as we can, and I think the reason's been given. Okay.
Thank you.
Anything?
I was just wondering if I just have a quick follow-up, is there language that we can get more people to do the waivers under the current legislation so that it doesn't take so long, even while the new regulations are being promulgated?
Any answer to that? Sabrina, Anna?
Mr. Chair,
Okay.
I'm not sure if we understood the question. If we could have her.
Okay, I can come back. I don't want to take your time.
That's okay.
I follow up offline. Thank you so much, Senator.
You want to move it along as quickly as possible, right? I think we all would like that.
Absolutely. I've got people who can't come to work and are and they should be at work. Thank you.
Okay, thanks. Appreciate it, Debbie. Anybody else from the public?
Mark Gonzalez, you're welcome to begin your testimony presently. Melissa Brown, you will be next.
Melissa Brown. Melissa Brown.
Mark Gonzalez, Mr. Chair.
Good afternoon. This is Mark Gonzalez.
Mark Gonzalez, okay. Mark Gonzalez.
Okay. Thank you again, everybody, for all of the hard work that you've been doing. I had a couple things that I wanted to bring up in terms of the factors contributing to actual waiver acceptance. And I know there were a few listed, but I wanted to go over the 9 that were currently being used by the Department of Professional and Occupational Regulation. It kind of falls in alignment with the Equal Opportunity Act. And the first one, obviously, is looking at the nature and seriousness of the crime. The second one being occupational nexus, the relationship of the crime to the purpose for requiring the waiver in the first place. Maybe even looking at the potential for reoffense in the position that the person is applying for, appropriateness of the relationship in terms of the occupation to the actual job position and the person that may be receiving services by that person who might be getting a waiver, prior offenses, age, the amount of time that has passed. I know that was in the legislation. Work history, and also anything that might incorporate the element of rehabilitation. If the person might be able to provide evidence that they have done more to provide services to the public or even in a private capacity to demonstrate that they have worked on improving their lives, improving their conduct and their behavior in general. So I just wanted to bring those 9 things up as things that might be included within the actual minimum criteria that is reviewed by either the departments when they're hiring somebody who might have a waiver, or private licensed companies that might be hiring somebody that has a waiver. Also, I wanted to ask, when should the waiver application process actually be initiated? I know one of the things that has been a concern is the flood of applicants that might be coming into the waiver application process. But I think that maybe if, like currently, I know that licensed providers will perform the background checks in conjunction with the hiring process. So I think that if we set the waiver up to be in alignment with that, so that the person may apply for the waiver only on the basis of they're trying to get a job in the service field now. That might help with the initial influx of applicants. So like right now, with the way it's presented, is the waiver going to be something that people are going to just go online and apply for right now? Well, not right now, but when it becomes effective and the regulations by each department has been established, is that something they will go online and just do, or will it be part of the job application process?
First of all, Mark, who you represent? Mark Gonzalez?
Hi, I'm actually just a interested party.
Okay. Yeah.
I have family members who provide service provisions,
Okay.
and I know that one of their employment hiccups has been they haven't been able to hire people who have had prior convictions.
Yeah.
And so it's a interest to them primarily, but I'm also interested in it because I know a number of people who are being serviced as people within homes, nursing homes, residential homes, group homes, and even foster care. I have friends and family who are actually receiving services in that capacity, who suffer from the lack of actual employment that the provider may not be able to provide because of the lack of applicants.
Yeah. Okay, thank you. I looked at these ideas, and I think we decided it's best to put that in the regulations as opposed to in the code. And I think they make sense too. And also, as a lawyer, I know just the analogy I have is federal sentencing guidelines. It used to be that unless you put down one of the categories for, say, as a criminal defense attorney in the federal court, if you didn't put down one of the categories that were set forth in the sentencing guidelines, you couldn't even argue them. Whereas I think a lawyer can become more creative and clever if we don't line them up. I mean, a good argument, you can, all of these things, I think, could easily be presented anyway, but, or at least in the regulations. I think that's the reason why we didn't want to put them in the code itself. Keep it more open-ended. Any discussion on this? I don't know if that answers your question.
It does to a certain
Yeah,
extent.
yeah.
I had another one. How will private providers be accessing approved waiver applicants? Has that been determined once the waiver application has gone through, somebody has been approved for a waiver, whether it's them doing it for themselves or them going through the application process and discovering they need a waiver? Whenever they do get that waiver, how do privately licensed providers access that information in terms of this person has been approved for a waiver so they can be hired?
The answer would be the application would be approved or not, one or the other. I think the agency would decide whether the waiver's been granted or not. Am I not correct?
I think the issue there, though, is that access to that sort of information might not be coming like the access from a private license, not a state body, not a state department or a state agency, but a privately licensed provider of sorts. Who, like currently, they're just the only process that they have in place is the background check that's mandated by state law. So how do they go about accessing the information that somebody who passes, who gets the waiver application in place and approved, how do they access that information in terms of this person has in fact been cleared by the state and has a waiver?
Well, under FOIA, it'd be a public matter, right? Yeah.
Mr. Chair, if I may, just to answer that question, on line 378 of the legislation, page 15, we've required that each agency or each department or board in their regulations include, if an individual is granted a waiver, they will include in their regulations procedures governing how such information shall be documented and disseminated to the appropriate persons or within the department.
Right. So that's on page
and in
15,
the record of employment.
Page 15, line 378. Page 15, line 378, under H, little 3 I's. Is that right? So that should explain it. Sabrina, is that right?
Yes, Mr. Chair.
Okay. Any questions? Mark, any other questions about this?
No, that's all that I had.
Okay.
Just looking at it from an HR perspective.
Sure.
If somebody goes through the process of working with, say, a group home provider, then they go through the process of applying for the job, getting their qualifications looked over, and at that point, if they qualify for the position, then if they've already I'm assuming they would have already gone through the waiver process at that point, or is it initiated within that actual hiring process? I guess is kind of where some of the questions that I've been hearing is coming from. Is that something that the actual employer needs to initiate on the behalf of the applicant? And if so, how do they get the information in terms of the results of that? Because it's one thing if it's the actual department who has access to that information directly, and it's another thing to put in a request during the hiring process as a private entity who doesn't necessarily have direct access to that information.
Anna or Sabrina, what's the answer to that?
Mr. Chair. Well, I think going back to the language that Sabrina pointed out, we also put shall be documented within the individual's record of employment or volunteer service. So I think that it's going to be something that gets established in regulations, because I imagine that could look differently across agencies, exactly how that information is given to private providers. But I'm not exactly sure if that.
My understanding, the individual would have to ask for the waiver, right? The individual.
Mr. Chair, yes, to answer, that other question, yes, the individual, I think, is going to have to initiate the waiver process.
All right, any questions there? All right.
Okay, so just for clarification, that individual would do that on their own time, hopefully even before they start the application process for a particular job they're interested in, so that way it can already be ready to go. It's not something that the employer will have to initiate upon receiving a job application, doing the initial pre-screening, and then getting to the background check, and then realizing this person has barrier crimes. Now we're going to initiate the waiver process.
Yeah.
Is that correct? It's going to be the former, not the latter?
The individual initiates the application, although the employer, I guess, could work with the individual if they know there's a problem in the
Sure.
background. Is that right?
That's correct, Mr. Chair.
Okay. Any further questions? Okay. Thank you, Mark.
Thank you.
All right. Who else from members of the public?
Mr. Chair, I've so far been unable to raise Melissa Brown, and so I believe at this time there are no members of the public remaining who wish to speak. Don't hesitate to raise your hand via the Zoom function if you are present.
Anybody from the public who has not yet spoken would like to speak? Have any comments one way or the other? Okay. All right, no further recommendations then, or no further comments from the public. Move on to number 4, members to make formal recommendation on the legislation.
Mr. Chairman?
Yeah, Senator Serval.
Do we need to, as part of any motion that we make here, do we need to do something formal to make sure that there's, perhaps the governor includes funding for this in the budget that's being prepared right now?
There is a budgetary issue. We do have to, we got to deal with the budget issue too. You want to explain the budget issue? Yes.
Oh, Mr. Chair, we can't explain the budget issue because we're not fiscal people, but I do believe Mike Tweedy said that the first time that there would actually be a fiscal impact for this would be in the next biennium. So that would be in 2024. Didn't he say that? I think that's what he said. He's not here anymore, unfortunately. But you could definitely add that as part of your motion to say, vote to recommend the legislation with the changes that you all agreed on today, plus with the recommendation to the governor that when the fiscal impact becomes relevant, that they would.
Yeah, there's a budgetary issue. Okay, is there a motion? See a price?
Yes, so moved, as was eloquently stated.
Second. Okay, there's a motion to move forward with the legislation to the General Assembly as a recommendation of this panel, along with a budgetary recommendation as well in the biennial.
Pardon me, Mr. Chair, is that it seems that would probably be two motions, one to change the nature of the legislation and another to formally recommend it. Is that correct, Mr. Chair? Did I misunderstand? Are we amending the legislation further, or are we now preparing to vote for? Okay. I think we have. Pardon me.
Okay, yeah, we have a recommended legislation, and the motion of Delegate Price is that we move forward and as the commission to recommend to the General Assembly the legislation that we have in front of us with the appropriate amendments, along with a budgetary request as presented. We haven't actually discussed that, but there's a budgetary fiscal impact that we have to look at as well. And so whatever the fiscal impact is, we'll ask the governor to put it in the biennial budget. If not, we'll ask the General Assembly to do that. So right now there's a motion to approve the legislation that we've discussed and present it to the General Assembly at the next session, 2022 session of the General Assembly. And this motion's been made and it's been seconded. Delegate Bagby? Okay. Delegate Price has made the motion. Delegate Bagby has seconded the motion. Any discussion? All in favor of the motion, call the roll.
Senator Serval.
Aye.
Delegate Bagby. Delegate Samira.
Aye.
Christy Kelly.
Yes.
James Abrenia.
Yes.
Delegate Price.
Yes.
Senator Edwards.
Aye.
Aye 7, no 0.
7-0, the motion carries. Okay, we look forward to presenting this to the General Assembly in January, if not sooner. And we'll have a House bill and a Senate bill.
Mr. Chair, before I do have a question before you.
Yeah, Delegate Price.
Okay. I guess it's more of a statement, but there were some good points that were brought up. And so is there anyone on that can explain how the public can be a part of the regulations process as the different departments are meeting so that some of these concerns can be raised in front of them as well? Or just
Ms. Allen, go ahead.
a public pronouncement that I feel like that should be a thing.
Yeah. Department of Health.
Yeah, I'm going to move down so I can use one that's not going to crackle. Mr. Chair?
Yes. Mm-hmm.
This one's also crackling. Yes, I think I'm setting it off. So in terms of public participation, there will, I would imagine, given the complexity of what we're talking about, the regulations would likely have to go through the standard process, which is a 3-stage process, each of which has a public comment period. In addition to that, each agency can elect, when they put out that notice of intended regulatory action, to go ahead and choose to hold a public hearing in addition to the public comment periods that would be held with each regulatory stage. Mm-hmm. And
Okay.
I will also say that they have the option to also convene a regulatory advisory panel at their choosing.
Okay. Any other questions? Okay, motion has been carried. I'll present on behalf of the subcommittee, along with Senator Sherrill, the Senate bill, and Delegate Price and Delegate Bagby. You all present the House bill.
Sure.
Great. Okay. Okay. Thank you all very much. Any other business to come before the subcommittee, joint subcommittee to study barrier crimes and criminal history records checks? Anything else to come before the body? Again, thank you all so very much, Legislative Service. You all have done a wonderful job. I appreciate it very much. And Sean, thank you too. And everybody who's been here to take their time to present your ideas, we thank you so very much. Look forward to seeing you in January, if not sooner. Okay. The meeting is adjourned.